Thank you, Mr Speaker. The Green Party will also be opposing this bill. It's a serious attack on workers' rights and conditions on a number of fronts. Firstly, it restricts union officials' access to work sites in a much greater way than previously. It makes it easier for employers to dismiss workers, not only through the generalisation of the 90-day trial period, but also through technical changes that make it easier for employers to win a dismissal case. And finally, it allows employers to communicate directly with their employees during a bargaining process so that on a day-to-day basis they can undermine the collective negotiations between the employers and the union that represents the workers. I want to talk first about the union access provisions that I addressed in my questions to the Minister of Labour today, and it is quite clear that there is no need for this provision in terms of the regulatory impact statement by Kate Wilkinson's own Department of Labour, which says that there does not appear to be widespread evidence of union representatives exercising their current rights to enter workplaces in an inappropriate way, resulting in disruption for business operations or adversely impacting on the employment relationship between employer and union members. And further on in that same document, it says that current arrangements provide an appropriate balance of fairness to employers, employees and unions. So what is the need for the change? The existing legislation provides a practical surround for union access. That is, the Employment Relations Act specifies that union access is restricted to reasonable times and reasonable ways, having regard to normal business operations and complying with existing health and safety requirements and security procedures. And what more do you want? And what is happening in this case is it will be much more complicated for union officials to get on to sites, particularly if there's an anti-union employer, because under the provisions in this legislation before the House, the employer can wait up to 2 days to even respond to a request for access, and then the response could be negative. Then the union has to get back and negotiate further, go on for days and days. And when you talk about an important conflict on the job, perhaps sexual harassment or something like that, a personal grievance that often requires immediate attention, the employer can just stuff the union around and hold them off for days and days to get onto the site. And even in a court case, the wording, the subsequent court case around access, the wording is so vague that postponements could be allowed for all sorts of reasons. The wording in the legislation is the reasonably practicable. The employer can deny access on reasonably practicable grounds. So then we have the 90-day trial period, which is supposedly to make it easier for employers to hire labour, but when you read the information we got under the Official Information Act from the Department of Labour in a document to Kate Wilkinson dated 8th of June, it says, in terms of the trial period that existed so far, very few employers used them for this purpose, that is, to hire disadvantaged job seekers, because of the potentially high cost of employing a candidate who was not the best or most able candidate selected from a competitive employment market. And it says that the very thing that the Green Party and others have been saying, it says in this report that some employees indicated that they had felt an increased vulnerability by being employed under trial periods. There'll be fear on the job and these workers will be scared to join a union, scared to stand up for their rights because they can be sent down the road at any time in that 90 days for any reason at all. And that is disgraceful, to divide the workplace between those 90-day workers who are scared about everything and the union that might be a bit more confident. And then we have the dismissal procedures. The unfair dismissal procedures through the employment courts and the like. And here there's a provision that if the defects in the employer's case or the process were minor or technical, then the worker can be dismissed. And of course, as has been said by an earlier speaker, there's not a redress through re-employment the way there was in the past. So this means that the worker finds it very hard to get justice if they're unfairly dismissed. And it's an important principle across all our law that we don't say, the problems in process were minor and technical, therefore the person who committed those breaches sort of gets off and can, in this case, do something very damaging to any worker, that is sack them, deny them of their livelihood. Losing a job is very traumatic, and I think we want to keep the disciplines in the Employment Relations Act that workers have to abide by the provisions of the Act if they want to go through with a dismissal. And then there is the question of collective bargaining. There is a well-established procedure, and the whole concept of collective bargaining is that it's the union on one side of the table and the employers' representatives on the other side of the table, and they negotiate. And it completely undermines that process if the union, which in this circumstance will often not even be allowed access to the workers very often to get onto the site to talk to them, if the union is at that disadvantage, the officials are outside the workplace finding it hard to get on, and then day by day the employer is coming and say, look, the union proposal to you is just a load of old cobblers, and the supervisors day by day talk to individual employees directly, say, you don't believe this, you don't believe that, and intimidates the workers so that you can't have proper collective bargaining on wages, conditions, whatever it might happen to be. So overall, if you take those issues together, it isn't that, as Kate Wilkinson said in her introduction to this debate, that the opponents of this legislation are blinded by ideology. These are very directly practical matters that are in this legislation affecting workers detrimentally in their real life situations. Being dismissed within the first 90 days is real life a bad thing to happen to you. Not being able to have your representative on the worksite, be it through negotiations over wages, conditions, or some immediate issue of bullying or something like that that's come up in the workplace, that is a real life problem that makes it harder in the workplace. To be dismissed and not be able to get your job back when the process has been wrong is a real life problem. And I think if you add it all up and then add to that what's coming next, and we'll probably be debating shortly, the holidays bill, the requirement for workers to get a medical doctor's certificate for just one day off sick and being made sicker in the process, that if you add it all up together, it's a very serious attack on workers' rights, a very serious attack on unions that are already, and you look at the situation with unions at the moment, in the private sector, the level of unionisation is not very high at all. And that's to a large extent because of the discouragement of employers to their employees, saying, you don't want to join the union, do you? And putting certain penalties around that sometimes. That is what's kept the level of unionisation in the private sector very low, lower than it was in the 70s, 80s, before the Employment Contracts Act. And also we live in a time of where the economy is not growing rapidly. There's relatively high unemployment. That has pushed down workers' real wages and conditions for 75% of workers over the last year, and that we need strong unions to address all those things. Thank you.